8 chapters, and how I like to give you 8 chapters and to tell you why are lawyers important, how do they think. And I like to start with the role of law in our society, the role of courts in the society. Just to stop it, right? Just to stop it in the society. All over the world, we have conflicts. All over the world, we have debates where we have a party who is starting and suing and somebody who has a different opinion. That means we lawyers have 2 duties. We have the duty to solve the conflict, and we have the duty to decide. In Europe, in Germany, quite often we have politicians who see problems but do not decide. The judge has the case, and we have a legal principle developed 200 years ago that every citizen, if he goes to the court, has the right that he will get a decision, that there is no right of the judge to refuse a decision. And that, I think, from a perspective of rule of law, is a very positive element, because we know we have to decide. And if you take a look how lawyers are working, we will discuss how we solve the problem later on. Here we have the first point of view, what is a typical element of legal thinking. I tell my students in the class, lawyers are willing to read, lawyers are willing to collect facts, and we learn that we have facts in antitrust law or in other areas who are very complex. And the fascinating idea of lawyers is that we can reduce complexity, giving a memo in 1 or 2 pages, suing in front of a court in 20 minutes. That is a typical time period in front of the Supreme Court in the United States, in front of the European Court of Justice, that we can structure the facts by giving you the most important ideas. So before we solve a case, we collect all the facts we do have, and we reduce complexity. If we now like to discuss legal thinking, we have a controversial opinion. Is there a simple answer or no? One opinion says law is so easy or so clear that we can create a one right answer. Each case creates a correct, simple answer. That is the idea Georgian, the American legal philosopher, created a couple of 20, 30 years ago by saying law creates clear answers. I think this theory is correct in simple cases. In Germany, for example, if you like to become the president of the German government, you must be 40 years minimum. So if a student like to apply to become the president of the German government, we would easily say, sorry, you are only 20 or 25 years old. You are not old enough. So here, the legal answer is easy and clear. But in the majority of the cases, and that is the reason why lawyers are needed in the society, answers are much less clear. Legal provisions are vague and not precise, or we have gaps and no clear answers. And so I think the one right answer thesis is only persuading in 1, 2, 3% of the cases, but the majority of the cases are less clear. The second opinion discusses law under the perspective of preconception. Preconception means, as a lawyer, I already have a feeling of an answer, and I know from my feeling the correct answer. And again, this theory is not very persuading, because we learn that law very often is very complex. We have rules, we have exceptions of exceptions. So it takes quite often hours or perhaps days before the best persuading rule and result is being created. And here comes my third opinion. I think the majority of our lawyers and experts say that law is very often not identical, not easy. And if we try to create an opinion, we have to argue. We have to fight for arguments. And so each opinion has to create arguments to fight for his position. And then a judge is checking the arguments, is looking which argumentation is more persuading, and sometimes he has follow one opinion and perhaps he creates a third opinion. So the idea is we are fighting for the best argumentation. And if you accept that courts can overrule their own decisions they have made perhaps 10, 15 years ago, it shows you that we are fighting for arguments. We have to check for the best arguments. There is no clear, definite solution for the rest of the time, for the rest of the world, because we have to check facts all the times. If facts are changing, we have to accept that also solutions are fighting. So our German Constitutional Court once wrote in the decision, law is the fight for the most persuading arguments. And so Hegel, that was a philosopher from the 18th century, he created the idea of a thesis, of an antithesis, and a synthesis. That means we try to fight for the arguments, and perhaps we create not only two opinions, but a third opinion, and the third opinion perhaps creates a position where both parties, the plaintiff and the defendant, are happy with. Why do I discuss this reasoning to you? Because the judge, a good lawyer, has certain rules to follow. And one rule is a very old principle, more than 2,000 years old, that was created in Latin, audiatur est altera pars. That means a judge, a good lawyer, has the duty to listen to both parties. Both parties have a right to tell the opinion. Both parties have a right to bring arguments for their position. And the judge has the duty to listen to both parties and to discuss and consider the arguments of each opinion. That means a good judge can't ignore arguments, can't say, I don't be interested in your arguments, but a good judge has the duty to listen to the arguments, to think about, and to check if the arguments, the legal arguments, are persuading or not, and to fight for pro and con arguments. I think that is a very important part of the rule of law, to show the importance of law. The importance of law, why our lawyers are needed. Why do we train lawyers? We train lawyers that they are part in society because we have the right and the duty to decide, but not only to decide, but also to persuade the parties by taking the arguments the parties give to the courts, balancing the arguments, and finally creating an opinion and giving reason for their opinion. And if you are a good judge, you not only persuade the plaintiff, but you also persuade the defendant, and you persuade all the people who are reading your decision. And what are the major principles behind finding law? It's legal certainty, because you create law, you create a decision that is binding both parties. You create justice because you have to decide who is right, who is wrong. And we call it legal peace. Legal peace because the fight is over. You find a final decision. And if your reasons are good, both parties are happy and accept the decisions. And then legal peace is perfect. It's not anarchy. It is peace. And legal problem in the society is solved by law. That was the role of justice in the society and the duty of reasoning if you take a look in their daily business. And now, in my next chapter, I like to start with the first way how to find the law. And all over the world, in Germany, it was Friedrich von Savigny, a German scholar from the 19th century, said, if you have a legal text, not only in law, but also in literature or in religion beliefs, we start with the wording. We look to the wording of the text and try to learn how we can argue. We look for the historical will and ask what was the idea the lawmaker had when they made the law and the statutes. We are comparing the wording with other wordings and texts in the code. And we are looking for the reason, for the theological background. I like to give you an example. In Germany and all over the world, you shouldn't kill somebody, you shouldn't harm somebody with injury. And in Germany, we have on the one way, the way that you damage a person, and you can damage a person, you can harm a person by a weapon or a dangerous tool. That is the wording of our criminal code. And my question is, what a weapon is clear, A weapon is a knife or a pistol, but what is a dangerous tool? It's an unclear, not precise word. And how lawyers think? It's a way of horizontal thinking, because we are comparing different cases. If you take the left side, the knife, if I take a knife and I use it against my victim, you would easily say a knife is a weapon. It's like a pistol, so it's a dangerous tool. On the other hand, you would create an example where you would say, it's obvious that if you take a finger and I put my finger here, my finger in your back, should it be a dangerous tool? Or you would say, wait a minute, with a finger, I can't create a special harm to you. The finger is more or less harmless. So if I compare it in a systematical way with the weapon, you would say, no, here a finger should be much less dangerous and should not be followed under the wording of this criminal code. And if you have clear cases where you say here the word should be fulfilled and the article should be fulfilled, the knife on the one hand, and on the other side, you have clear words here, the finger, where you would say here you do not have any dangerous possibility. When you could create in the middle more complicated examples where you have to argue, and consider the spirit of the rule. And the spirit of the rule would be, can I create special additional harm if I use a weapon? You say with a weapon, clear. With a finger, not at all. And now take the heavy boots, the shoes. And here you would perhaps say, if I knock my boots against your feet, it would be perhaps not harm you in a special way. But if I use the heavy boots and kick it against your head, you could say, wait a minute, I can be killed. And then we should say a dangerous tool as a precondition is being fulfilled. This way of horizontal thinking, I like to tell you in two important cases, the analogy on the one hand and the theological reduction on the other hand. That are legal figures, that are legal arguments that we find all over the world. Analogy means the wording of my statute is not fulfilled, but can I apply the wording of your statute? Also, the wording is not fulfilled in my case. We had a very famous case played in the 30s, in the last century, where Lord Bryan, a famous legal author, studying in Oxford, went to a library. The Oxford Library had a rule that says it is prohibited to bring dogs in the library. Lord Bryan was very disappointed because he was very excessive, a very interesting guy who didn't like to follow rules. And he said, okay, if I do not have a right to bring a dog in the library, today I'm bringing a dancing bear in my library. A dancing bear. And here the rule said only dogs are prohibited. There was nothing about dancing bears. And now, if you like to structure your argumentation, the legal argumentation to persuade by filling up a gap. You start with the idea that the rule is not clear, or the rule does not prohibit bringing dancing bears in the library. But if you are looking for the purpose of the rule, why do we create such a rule? The rule has, of course, the idea perhaps to make sure that students can study properly in a library, that students can concentrate, students should not be beaten by dogs or dangerous animals. And then on my third step, I could argue there is a similarity. There's a similarity between a dog and a dancing bear. Or to create a stronger argument, if already it is prohibited that a dog can take it in a library, then we should also make sure that a bear should not be brought in the library, because the bear is more dangerous than a simple dog. And here you should learn, or you could argue, that the principle of equality forces you as a lawyer, as a judge, that similar cases or equal cases must be treated equally. Because everybody, every citizen has a right that equal cases must be treated equally, and that you do not treat your friend or your mother or your girlfriend better than another person. So you could argue here the similarity is so strong that also we have a gap. We can fill up the gap, we can extend the rule that not only dogs, but also dancing animals, dancing bears, should be prohibited. A technique of horizontal thinking that I could not only train in Germany or in Italy, but I think all over the world. Because we have to answer the question, do I have a right to fill up the gap or not? And here we have a 4-step structure, how we must argue before we have a persuading answer. We can't only start with a thesis, I have a right to fill up the gap, that is a thesis, but I have to give reasons how we can fill up the reason. And now I do just the opposite. I do, from a logical point of view, just the opposite. Again, horizontal thinking. But now the word of a statute is fulfilled. But in my case, you would argue the reason, the purpose does not fit. I need an exception, and the lawmaker forgot this exception. So, all over the world, we have parks, places where you can relax. The rule says vehicles, cars are prohibited. And now my question is, can I go with an ambulance car into the park to help a person who has perhaps a heart attack, and where I like to make sure that he will not pass away? So we would argue, wait a minute, we must find an answer. And here again, I like to show you how lawyers are thinking to argue. Opposite to our analogy, you say, here the wording is fulfilled of the statutes. But again, if you're looking for the purpose is that you must avoid that you have normal cars in the park and that you can relax in the park. But I think it's persuading to make an exception if you consider that somebody needs help, and to make sure that he can be put to hospital, you allow the exception that the ambulance car when the ambulance car is using the park and the streets in the park. So here it's not an argument of similarity, but of dissimilarity. The two cases are different, and because the two cases are different, we are allowed to treat them differently. So we don't use the car because we have a lazy man who don't like to walk in the park. We use the ambulance car as a way to help the people. That is my first step of finding the law, using 4 or 5 arguments of interpretation. And now we can make it a step more complicated. I call it substantiation. Try to make vague clauses more concrete by creating additional legal instruments, by creating additional legal preconditions to find the law. And here I find a nice cartoon, it had been translated, the lawyers don't like to, That is a typical, I don't know if you also have it in China, it's a typical person, the right person, that is the death, the death, who tries to bring you, to kill you. And here on the left side, we have a judge or a lawyer who says, I'm not willing to pass away, dear death, I'm not willing to be killed. So if you say your time is up, how do you define a way to be stopped? So here in this chapter, we have a problem, that general clauses, like the duty of good faith, can be used in legal cases, and how we can work with ambitious legal terms. Perfect world would, in a starting point, that the legislator, in a first step, create general clauses, but then in a second step, creates so-called legal examples. In German and in the European antitrust law, we have, for example, a prohibition of market abuse, and then we have a definition and examples of market abuse. And then we learn that if you dictate the prices or if you make a cartel, then you are abusing your power. So best word, and that is the way our lawmaker quite often helps you, is giving legal examples or giving an appendix where we have examples to create higher and general classes in a concrete manner. But there is only one technique. Another technique is the role of the courts that we have. And how can you do it? Just give you an example of our case with the weapon and a dangerous tool. Weapon and a dangerous tool in a horizontal thinking compares one case with the other. But not only in Europe, in the United States, we create rules and principles out of a couple of cases. And here we combine horizontal thinking with vertical thinking. That means we are creating a new rule, a new precondition that makes it easier for you to check if a dangerous tool is being fulfilled. If you compare the knife and if you take the heavy boots, you can argue that are instruments where you have a high risk of a significant injury, that these instruments having a high chance that you will be hurt and injured in a stronger way. And if this probability is fulfilled, your case is fulfilled, and then the wake clause, dangerous tool, is being created more precisely. And if you take the right side, you say, if I'm just wearing slippers, if I put my finger in your back, if I cutting your hair as a hair cutter, there is no higher risk of significant injury. Yeah, that are cases where you would say, wait a minute, these cases should not fulfill this dangerous tool idea. Okay. Next, jump. Balancing. Balancing as a concept. Balancing is another way of finding a law by taking into account different instruments. If you like to build a railway in Shanghai, there is a high-speed railway created by the Germans, that is going for 300-400 kilometers. And if the land mayor, the mayor of the city, would like to create a new railroad, we have the interest of a railroad company. We have the interest of the society to go from one city to another city as quick as possible. We have the owners of the property where the railway should be construed. We have perhaps neighbors who don't like additional noise. That means we have different interests where in Europe, for example, if you are buying a new highway, all the interests must be balanced and taken into account. Or mention biodiversity, small animals perhaps who should be protected in the area. Take environmental regions, how much climate change would be followed if you are construing a new highway. So that is a typical instrument in European law. And one solution to find a solution between the different instruments is the so-called proportionality test. Proportionality test means I have to take different instruments into account, and I have to make sure that both sides are being taken into account. That means everybody has the right to give arguments, and then we try to find a solution. Here, that is our railroad train, maglev train, I already mentioned. And here, that is the proportionality test, where we try to find a solution between the two different parties. And I also like to show you how our German Constitutional Court find a solution between different instruments. We had on the one hand a murder. Mr. Lebach, killed several people and was brought to prison for 6 years. That was on the left side, the plaintiff. And on the other side, we had our media, our television broadcast a company who said, I like to make a film about this case, and I like to make it public. So here we had human rights, the human right of privacy, the human right that that I have a right to be part of a society after a couple of years. I stayed in prison. I should be part of a society again. Privacy would not allow to make my background public. And on the other hand, I have a right of news. I have a right of the press, who has the right to make things public. And here we learn that balancing creates arguments by presumption rules. I can create stronger and poorer arguments if I say my argument goes through because it is the strongest argument, or I have a so-called presumption. That means you have to counter-argue if you do not like the presumption. And here we have on the one hand the freedom of press I mentioned. We have on the other side the right of personality. And here the German highest court, our fundamental court, says the first presumption says the right of information is stronger. So you have a right to talk about the crime and the case. And presumption rules have rules and exceptions. And here we have the first exception. It's not necessary to identify the murderer. It's sufficient if you inform the public in a general way. Because here you have the second presumption, we have a right of a murderer to resume life in society, to become a good person in life again. But here again, we have an exception. If there's a special interest, if there's a special interest of the public, we still must have a right that after 5 or 10 or 15 years, we can also inform the society. And so we have hundreds of cases where our courts are balancing interests by not giving a simple answer, A is right or B is right, but by trying to make sure that both sides can have a certain area where we say, in this case, my right is stronger, and in this case, yeah, I can get my right. After we spoke about the horizontal way to find law by comparing cases, by balancing different interests, we have another way to find the law, and now by a vertical way of thinking. We call it the legal hierarchy. The legal hierarchy is an idea which was created by Adolf Merkel in the 30s of the last century that says, in some areas, we can have conflicting rules. A rule says yes, and another rule says no. And a typical example of conflicting rules are the multi-level areas of law. Everybody of you is citizen of a city. Everybody of you is a citizen of a region. Everybody of you is a citizen of a province. Everybody of you is a citizen of China. And everybody of you has perhaps followed some international rules. So in Europe, but also in the United States, and I think also in China, there can be a conflict between the federal level and the state level. Because in European law, for example, some states had customs, and a European rule says customs are forbidden. If one rule says customs are forbidden and another rule says customs are allowed, we have two conflicting rules and we lawyers have to solve them. And a fascinating idea that we already had 2,000 years ago says higher law can move the lower law. Lex superior derogat legi inferiori. If we have conflicts of law, in German, for example, our German constitution says that our federal law is higher than our state law. We have 16 states. So if our state law has an opposite ruling than our federal rule, judge, a lawyer must ignore the state rule and is only allowed to use the higher rule. That is the idea of lex superior, yeah. Higher ranking law takes precedent, higher law has to be followed. And because we are now living in a more and more global world, we have more and more legal rules that exist. And then we have to consider very strongly, is there any additional law that conflicts with my rule? And can we solve this conflict? One idea is I take the higher ranking law. One idea is I take the later law. If we have laws in the 50s, 60s, 70s, we say the later law is relevant. Or another rule says, if there's a general clause and a precise clause, I have to take the special rule. For example, trademark law is more special than unfair competition law. Or if we have antitrust law, that is more special than our general tort law. And so that is a way to find the law and to get out of conflict. And here we can create wonderful pyramids, that you know from Egypt, 2,000, 3,000, 4,000 years old, this pyramid, where you can put the different levels on law to learn which law is higher and less high. If you check here on the bottom, you see our state law. That is the state law of 16 members. Then we have our German law, our constitutional law, and we see that normally our European law is higher than the national law. The same system you have in the United States, that the federal law is higher than the national law. And sometimes we have international treaties, and then you must check if also the international treaties are binding the member state, so that we have to follow them. That is one way of thinking, but I tell my students we have rules and we have exceptions. So I also have to give you another idea of our legal sources and legal thinking, and that is much less clear. It is not the idea of hierarchy, where you put the different articles and codes in an order and say what is higher or what is wrong. It's called a network thinking. Network thinking means that we have rules. We have, for example, general clauses in tort law. But more and more nowadays, we have private law, and that private law and statutes are influencing our state law that is being organized by or created by our lawmaker. In skiing, when we are going skiing in the Alps, we have private ski rules who has to take care on the skiing route. In company law, we have corporate governance codex that are private codes that make our company law more precise. because we need the expertise of private bodies, we allow private bodies to create rules. In the past, we said, oh, it's soft law. We have no idea how to use it. You can ignore it. But nowadays, we more and more learn that it's perhaps less binding than the statute of a lawmaker. It has a legal relevance that you have to take private law into account and that you have to consider it. I created an idea that we not only have primary binding law and so-called soft law, the left pillar and the right pillar, that is the classical way how we think law exists. But I said, no, we have not a dichotomy, but a trichotomy. That means we have nowadays 3 pillars, and in the middle we have a way of law that is not binding in every case. So it's less strong than a legal statute. But I have a legal duty to take these rules into account, have to discuss them, have to follow them if I don't have better arguments to overrule them. I have a right to overrule them. I have a right to counter-argue them because we are not full binding, because we are private rules, but I have a right to go on and I have a right. I have to follow them if I do not have any argument. 7th chapter. One of the most complicated areas is the question, how far is the right of the lawyer? How far is the right of the judge to create new principles, which you cannot find in the statute? To overrule the old decisions, to fill up gaps because the code does not give you a clear answer. And we call it the development of law. Of course, it's in the right and the duty to develop the law, but we have to ask for borders, to limits. Where are limits? Because you ignore the right of a lawmaker, which make the law. And so we have boundaries, we have limits, but the limits are also vague, so that we need a couple of arguments, to make sure that you have a right to do it or not to do it. And we can argue with the arguments. If, for example, the historical will says no, it's much harder to say yes. Or if the legal consequences would be to harm citizen, it would be against a development of a law. Or if international or higher ranking law forbids a certain element. So each time we have to consider carefully what is the role of the lawmaker and what is the role of the judge. And normally we can only create in a wide way new law if we would clearly say the status quo, the law is injustice. It would harm a person, so that it's necessary to go on and help the person. So, my last chapter. Why do I speak about a modern legal methodology? What is new in my books? Because we have books about legal methods for the last 50 years, and already 50 years ago, books had been created in legal methods. My idea is that we really have to counter arguments, that we have to find and create as more arguments as we can find to fight over different positions. Yeah, if we accept that a typical idea of law is a conflict, and that a conflict must be solved, we have two opinions. We have a plaintiff and a defendant. Yeah, and both parties have arguments. If we wouldn't have arguments, there wouldn't be a conflict. Yeah, the conflict normally, especially if you go to our highest courts, are a conflict because both parties think we are right. Yeah, I am right. And so I have to take my arguments seriously and have to consider how strong are your arguments and can you argue or counter argue. And here, a postmodern approach 10, 15 years ago said, sorry, legal methods does not help at all. Our lawyers creating a decision, we call it process of discovery, and at the final end, we just give reasons. And I'm not happy about this idea because I think we lawyers must work as close as possible with our legal sources. Our legal statutes are binding, and so we have to take care our legal codes, our legal articles, and have to fit our legal solution in our legal methods with our legal methods we do have. And that is the reason that I created a structure how we can find the law and what you should make in hard cases. Yeah, if cases are easy, we don't need lawyers. But if you have hard cases where you cannot create an argument easily, then you should use a couple of steps, collecting the facts, looking for our 70 interpretation canon, looking for our substantiation, looking for higher ranking law, looking for the limits. That had been examples I just gave you in my lecture. Yeah, and of course, making a justice control at the very end. That is the first idea. And the second idea is that our arguments have a different power, a different weight. Yeah, we have very strong arguments. I call them priority clauses. Yeah, if in your country your higher law pyramid is being accepted, and if you have a rule that says federal law is stronger than state law, then you can't argue anymore. Then this rule accept, and then you have to follow the higher law, and such priority rules are clear. Or in criminal law, we have this principle nulla puna sine lege scripta. That means no law, no crime, no punishment without a fixed rule. That means we are not allowed to use analogies in criminal law. We only can trust the wording of a statute. That are priority laws. Still quite strong are presumption rules. Yeah, presumption rules are a clear wording. If a clear wording says yes and yes, it's a presumption that the wording is correct, and then you have to counter argue, and then you have to look for the exceptions. Yeah, so I can structure my different rules in different ways. Yeah, and again, yeah, the poorest way of arguments are so-called formal arguments. What are formal arguments? That are arguments that can very easily counter-argue. We have all over the world a rule that says clear rules are not allowed to be interpreted. Clear rules are not allowed to be interpreted. That is a formal argument rule. And I ask my question, is this rule persuading? And my thesis is no, this rule is not persuading, because that is a rule that only works with a thesis without giving arguments. Yeah, if I have to check if a word is clear or not clear. I have to interpret it. If you forbid me to interpret the rule, then it's just a thesis and it's not a good argument. And my example is, how many minutes constitute an hour? Is it a clear rule? My student says yes, 60 minutes. All over the world, clear. And I tell my students, sorry, we have a 2 hours class, and my 2 hours class finishes after 90 minutes. Because an hour is 45 minutes in an academic world. So it gives you an example that you should be very careful by saying the wording is clear, it's forbidden to interpret it. Because it's just the opposite, yeah. You must interpret the wording in the context where you are. And in an academic world, an hour is different to normal life. And when we call it the relativity of legal terms, yeah, then this rule is more persuading, yeah, that if you have good reasons to change the wording in your context, you also have to follow this rule. So instead of a summary, yeah, the book I've written is the idea that if you are willing to train and learn these arguments you find in the book, yeah, that are more than 150 arguments, that not all of the arguments can be used in your country, but perhaps 3/4 of them, and that it gives you the skills to argue and fight for the different positions and to look for different solutions and really be neutral, to take each opinion seriously, awakening and collecting as many arguments you can find, and then balancing the arguments to create the most persuading answer. The most persuading answer is the answer where the majority of the audience would follow you and would say, okay, I can live with the best of the 3 solutions, the best of the 3 solutions. Here, this solution is the best one. So you can create legal certainty, legal power in peace with your best answer. So I like to stop here after more than 60 minutes, yeah, of talk. And I'm very happy to listen to the different comments. Thank you for listening.
Thanks for Professor's very excellent lecture. And he has just in 1 hour to give us a whole outline of his legal methods. And if you want to get more information about his legal method, you can see Professor's the thick book, Legal Method. We have translated into Chinese in August. All the contents the professor has give us will show in detail in that book here. And now we will go into the stage of comments. The first one is the professor's assistant, Tobias. Tobias, yeah.
Yes.
Tobias.
Thank you. So regarding Professor Meller's lecture, one of his lead questions was, why do we need lawyers? And so I want to have another look at this topic, recurring to the most important points of his talk and extend it to the question, why do lawyers need legal methods, which we heard of in his talk. So legal methodology is a theory of legitimacy, which is primarily a constitutional aspect. The European legal tradition includes legalism, which gives the state the exclusive authority to provide law and legal developments. Furthermore, the reservation of statutory powers and the theory of materiality demand fundamental decisions to be made by the legislator. However, legal methods are expected to limit the power of judges within the separation of powers. The judiciary is required to accept the primacy of the legislator. Thus, first of all, the legal methodology binds the lawyer to the law. For judges, this leads to some kind of judicial self-restraint. So courts are expected to hold back in their decision-making while granting legislation discretion in fundamental political questions. Finally, that means that developing the law is prohibited as soon as it ignores or eliminates clear basic concepts of the legislation. Legal interpretation shall not become an unlimited interpretation, as we already know, Reuters already stated back in the 1960s. In other words, judges shall not become a legislative judge and substitute the legislator. This means judges are not called upon to examine whether a legislative solution is the most expedient or equitable one. They must respect the given decisions of the lawmaker. From another point of view, the power of judges is limited towards the parties in court by binding the judge to the citizen. So legal methods try to prevent decisionism, like when the decision is made of the sheer power of the judge or is his subjective preconception. Thereby, legal methodology ensures a rational reasoning, as it is not only a theory of legitimacy, but also a theory of argumentation. It gives lawyers the tools to deliver reasonable, in best case, convincing decisions. But at least legal methods can prove that certain decisions are wrong when they infringe fundamental legal principles, such as the limit of the wording, just like in the example of the dangerous tool in criminal law we heard of in Professor Möller's lecture. Like we heard of, a finger can't be a tool in the sense of criminal law. The goal is to find a fair solution and increase the persuasiveness and acceptance of the ruling. But legal methods also structure legal thinking to avoid so-called pluralism of methods, where the deciding judge is simply cherry-picking arguments instead of weighing and balancing them. The aforementioned 6 examination steps towards a legal solution from Professor Möller's and his book Legal Methods support the lawyer in doing so. They ensure no relevant argument is overseen. This is one of the most, in my eyes, one of the most important reasons of the success of the book, as using the steps overcomes weaknesses in argumentation, like decisionism, pluralism of methods, or in general, a lack of reasoning, and these steps streamline the lawyer's argumentation. So Professor Möller's legal methods combine the classical and postmodern methodology to a modern legal methodology. In particular, the legal methods give lawyers the opportunity to also create legal solutions in hard cases where the sheer wording of the law is not expedient and lawyers are truly needed to solve previously unknown problems. In these hard cases, a lawyer's task is not only the discovery, but also the creation of law. At the same time, the lawyer or the judge is aware of the judicial self-restraint and also is guarded from crossing the lines of separation of powers by using the legal methods. Within these lines, the judge is even allowed and sometimes obliged to develop the law. Thereby, legal methodology ensures a rational reasoning, even in political cases where the lines are blurring. For example, the US Supreme Court is taking over political decisions more and more, and also the German Constitutional Court's decisions are sometimes of political nature. So when in doubt, courts are also called upon to refer political questions back to the legislator. So the main decision is still made by the legislator. Thus, in the end, the second theory of argumentation recurs to the first theory of legitimacy, as both are expressions of legal methodology. Thank you.
Thanks for Dr. Tobias' comments. And next commenter is Professor Li Zhongxia. Yeah. 中夏，
好，
中夏。
谢谢这个李浩老师。Sehr geehrter Professor Müller, herzlich vielen Dank für Ihren ausgezeichneten Vortrag. Ich freue mich sehr, Sie kennenzulernen. Auch ich freue mich sehr, an Ihrem Vortrag teilzunehmen. leider wegen der Sprache nächst werde ich auf Chinesisch sprechen. 这个中南非常感谢啊，这个咱们中南财经政法大学各位老师的邀请，感谢这个申老师的邀请，也非常荣幸能够参加这么精彩的一个讲座。那我想呢，这个Melis 教授啊，这个法学方法论这本巨著啊，我想我们都已经读过了。我是已经呢这个非常认真的读完了这本书。那我想呢，从中的收获也是非常的大。对于这本书呢，包括 Melis 教授的讲座呢，我大概自己呢有2个这个不成熟的一点学习体会。那么第一点呢，我想呢，这个 Melis 教授啊，是通过这本书，那么告诉我们，就是说，为什么我们需要一个法律人的思考方式，也就是说呢，是告诉我们法律人如何去思考。这在我们国家可能，我想呢，李浩老师啊，各位老师，对这个背景呢都是有了解，不是所有人都能够接受，就是说存在法律人思维方式这件事情。尤其在咱们中南这个财经政法大学法学院啊，这个我们的院长啊，这个也是我很好的朋友。我想呢，这个他们这个其中的这个社科法学，可能很多人是不认同这一点的。认为不存在一个独特的法律人的思考方式这件事情。事实上呢，我们其实也都了解，我们也看到美国的尤其我们做宪法的，美国的宪法判决也好，德国的宪法判决也好，很多的判决它其实都是价值先定的，政治先定的。我想 Melis 教授呢也是不否认这一点的。但是呢，他通过这本书啊，告诉我们为什么存在价值先定、存在政治先定的情况下，那么我们还是仍然需要一个法律人的思考方式，我们仍然还要一步一步的去做法律论证，一步一步的去把我们如何做出这个法律判决这件事情，那么通过一整套的一个方法体系去把它讲述出来，这件事情为什么这么重要？我想呢，这个事情呢，我自己呢也做一点社会系统论的一个研究。卢曼呢也曾经在他的系统论里讲过，法律系统所承担的唯一不可替代的功能，就是稳定化、规范预期的功能。那么如何去实现这个功能呢？那我想我们的法教育学的这个工作呀，法学方法论的这个工作，在很大程度上其实就是辅助这个法律系统。要实现这个要实现这个法律系统的功能，就是稳定化、规范预期的功能，让法律呢具有明确性，让法律呢能够这个公开透明，那么我们呢每个人呢都能够预期到自己的行为以及自己的后果。这个呢，我想这个事情呢，对于我们国家而言呢，应该来说它的重要性是不言而喻的。这个呢是第一点这个体会啊。第二一点体会呢。我想呢，Melis 教授呢，在这本书里面也提到了，就是说我们这个法学方法呀，它的本质到底是什么？以前呢，我们对于方法的理解，我们说方法就是为了得出一个唯一正确的结论。你要通过一个科学的方法，然后去通向真理。这是呢，我们对于传统啊，我们对于这个方法的一个理解，包括呢。从萨维尼开始，包括概念法学，那么对于方法的理解都是这样的。因为存在一个唯一正确的答案，我们要通过方法、特定的方法、科学的方法，然后去找到它。但是呢，Melis 教授呢，在这本书里边其实已经告诉我们，就是说方法呢不一定是能够通向唯一正确答案的。那么我们为什么还需要方法呢？那么因为我们需要方法去进行论证。也就是说，在法学当中，重要的不是去得出唯一正确的答案，而是在于去论证，去说出你的理由，你为什么做这个判决？你说出你的理由，然后呢，试图呢去说服别人，让别人去接受你。当然，你也可以不接受，然后呢，你也说出你的理由去反驳他。所以呢，这个事情呢，方法的这个本质就发生了变化，它不再是找到唯一正确答案，而是呢，要试图通过方法去建构一个论证的体系。那么这个方法的本质发生变化之后呢，那么与之相伴随的呢，就是整个法学方法论的体系可能都要发生变化。传统的那种方法论的理解呢，那么是以逻辑为基础的， 而现在呢，我们对于方法论的理解呢，那就不再是一个逻辑为核心的这么一个东西。当然，逻辑还是很重要，概念还是很重要。但是你是不是说它完全就是通过逻辑建构起这套体系？那肯定不是。所以在这种情况下呢，我们对于方法的这个理解呢，就要有一些突破性的认识。我们也能够理解到法律当中不可避免的会存在法律的漏洞。那么法律的解释不可避免相伴随的那就是法的虚造。那么法的虚造呢，在某种程度上呢，那么又要这个超出法律的文本。那么这是一些不可避免与之相伴随的不可避免的一些工作。那么它是环环相扣的。所以在这个程度上来讲，我们说 Mills 教授呢，这个法学方法论它是现代版的法学方法论。那么显然是这种夸奖呢是不为过的。那么也就是说，我们现在的整个的法学方法论的构造呢，就是 Mills 教授在书里边所展现出来的，通过文本解释建构，通过漏洞填补与法的虚造来展开的。那么这也是呢，我们实际上今天所有的法律人可能共同要面临的问题。那么这是呢，就是说第二点呢，我的一个体会。那么关于以上呢，就是说呢，这个学习体会之外呢，我对于Mills 教授呢，我还有2个问题，我自己也是自己思考的一些问题，包括因为我是做宪法的，所以呢，关于围绕这个宪法学方法论啊，我自己也有一些这个体会。那么第一个呢，就是说，我们通常会认为说方法具有共通性，因为方法是中立的，方法呢某种程度上它是这个要超越于价值判断的，是价值中立的。但是呢，我们会看到实际上来讲，呃，无论是这个宪法还是宪法跟民法还是刑法来讲，那么在方法论上可能是有不同的。那么宪法相对于民法和刑法而言，它是有它自己的特殊性的。这个特殊性呢，其实就是跟二战之后啊，那么德国联邦宪法法院的建立，明确确立了宪法呀与部门法之间的一个效力位阶的关系之后，那么所引起的。这个特殊性呢，就在于宪法是现代法律系统当中一个自我反思的机制。这个法律啊，如何避免它成为拉德布鲁赫所言的那种不法的法律？那么，我想宪法起到了很重要的一个控制作用，它是一个自我反思的机制。那么，这个自我反思的机制就意味着说，宪法其实要更多的成为价值的来源、价值的根基，整个法律系统的价值的根基。这就意味着宪法的续造跟部门法的续造可能是不一样的。一方面，它要更经常的去做这个法的续造的工作。另外一方面，它的这个续造是一种根本的价值上的续造，也就是说，某种程度上它是一个价值填补的作用。甚至呢，你可以说它不仅仅是法的续造，它是整个法律体系的续造。你比如说这个，在美国、在德国、在中国的宪法里面都没有隐私权这个建构，但是呢，我们会看到，无论是美国、德国，包括我们中国，它都会通过各种各样的方法，通过自己的路径去建构起这个隐私权这个东西。美国通过正当程序条款，然后通过未列举的权利这个路径；德国呢是通过一般行为自由。那么中国呢，我们中国也可以通过38、39、40条，还有包括我们的33条这个人权条款，那么同样可以去建构这个隐私权。而这在宪法上是没有的，你是无中生有的去建构出这么一个东西来。那它甚至带有很强的价值性，它会影响到整个部法的建构，包括你看我们最新这个通过的个人信息保护法的这个建构。所以呢，我想呢，就是说这个续造，它就跟一般的部门法的这种续造又不一样了。你像刑法呢，因为它的续造是要受到严格限定的，它是罪行法定原这个影响。米尔斯教授在书里面也反复强调这一点。那么对于这一点呢，我想呢，请教这个 Mills 教授，就是对于宪法的这种特殊性是如何去看待的？第二一点呢，那么这个 Mills 教授呢，对于这个方法论的法学方法论的这个体系啊，应该非常的清楚。这个解释、具体化、建构、法的续造等等这么一个体系脉络去展开。 但是我想问的一个问题呢，就是我们的解释跟这个续造啊，跟建构能不能够截然去分开？它是不是真的能够分开，完全去分开？因为任何的解释其实都是带有续造的性质，都是带有建构的性质。我想呢，对诠释学啊有一定了解的，肯定对于这个问题是不陌生的。所以呢，我也想请教，就是说米勒教授，是不是就是说在法学解释当中，其实当然也肯定是存在一些说明性的解释啊等等这些，但是呢，绝大部分的工作，包括疑难案件当中的解释，其实都是跟建构是有关系的。那么以上呢是我这个存在的两个问题，想请教米勒教授啊，同时呢也请教我们在座的各位老师。那么以上呢是我一点这个不成熟的这个心得体会。那么也请呢我们各位老师、各位同学呢多多批评指正。好，谢谢大家。好，李浩老师，
Thanks for Professor Zhong's comments from the view of a constitution law. Yeah. And the next commenter is Professor Chen Lei. Yeah. 陈磊兄啊，陈磊教授。
Professor Li Hao, so thank you very much for having me. And it's my great honor to be invited to be the discussant for the thought-provoking and insightful presentation made by Professor Thomas Mullis. In the interest of time, I only talk about 3 points on the technical points. I made a short presentation slide I would like to share. Because the previous 2 commentators had discussed extensively about jurisprudential value of this book, which is very influential across the legal families. Professor Mullis, in his presentation, draws lots of case examples from German legal system, but actually it sounds very resonating because as an arbitrator, as someone who often frequently showed before the International Commercial Court and the International Commercial Arbitrations, I find it very engaging to, oftentimes when I hear what he is talking about, I just take a pause to reflect upon certain theories. So I only have 10 minutes, so I just focus on the three points which I like to draw your attention to. The first one is the role of courts in society. I think that lies in the essence of the whole book, because that is the foundation, right? Simply because we need to have a court which provides a well-reasoned judgment. That's why we need to educate the future generation of legal professionals on these legal method skills. What I'm trying to highlight here is the well-reasoned judgment not only bring justice and promote the rule of law, as rightly pointed out by Professor Mullis, but it also enhance the public trust over the judiciary. A Chinese typical example, right? Because in the long past, the Chinese judgment has been notorious for providing a very short, sketchy judgment. But to be fair, in the last decades, Chinese judiciary has made steadfast progress by taking lots of initiatives, by producing the lengthier, the more well-reasoned judgment. I think that is linked with this public confidence or trust over judiciary, because what the ruling parties fearful most is the people, when they have disputes, will not use the court, right? They settle privately. I think that is not in line with everybody's thinking. And in this sense, ruling with reasons is to promote transparency and to promote certainty, because the parties, litigants, will often have a certain level of predictability before they decide to go to the court. I think in that sense, the legal methods training is a public good to the rule of law. So that is something we really need to pay special attention to. The second point, I look into the 6 examination steps to determine the legal solution by Professor Mullis. In the interest of time, I will not talk about each and every one of them. Rather, I will just focus on the first and the last one. So the first one is the fact-finding. The term I quoted from Professor Mullis' presentation is hermeneutics of the facts. Because in practice, in real life, right? Very often, this fact-finding process has been downplayed by the lawyers because oftentimes people say, well, we are lawyers, so we have, we are well equipped with the necessary and the requisite legal knowledge to fight for the clients. So, the fact-finding is just the job done by the factual witness and the written documents. They may not take particular attention to it, but this is not the case because as we all know, as for legal practitioners, this turned out to be the most time-consuming work for the lawyers and the judges, right? So even in the cross-examination before the common law courts, right, before the court in Hong Kong, Singapore, or London, very often even a foreign legal law expert will clarify the legal positions of foreign legal system within its particular context with the facts. But the thing is, the courts usually, particularly the common law court, may not be very interested in knowing the whole picture of what happened in the last 5 years, 6 years, as the case may be. And what they really want to know is what are the most relevant part in the whole story, right? I think Professor Morris rightly pointed out in the presentation that there are some taxonomy nuances in this process because we have to differentiate between the simple cases and complex cases or hard cases. Because in complex cases, taking investment arbitration, for example, you can't. It's neither possible nor necessary for the tribunal or the court to dig out what happened in the past on each and every details. So in that situation, obviously, there is a huge demand on the lawyers and the judges, arbitrators, to have this essential skill, singling out what are the most relevant to the legal issues at hand. So I think that is very crucial. We cannot just take this very lightly. The last point I want to make is about fairness control, right? So I totally agree with this scientific legal method articulated by Professor Morris, right? There are lots of limits, there are hierarchies of laws, there are some argumentations into this process, but at the end of the day, ultimately, when you have the facts in your hand, when you find the relevant laws, you know which law gains the precedence over the others to be applied. Then you have to have this kind of control mechanism to determine the final outcome. In the sense that fairness is a magical word, right? So everybody will not say, well, we don't want fairness. Every lawyers, all judges, arbitrators loves it. But it often debate what is fair in the given circumstances in a particular case, right? So what I'm trying to say is it is situational and contextual. It's not like rock science. Fairness is absolutely certain and predictable. It's not the case, particularly in the hard cases. In most cases, fairness is not controversial, right? For most of simple cases that are quite straightforward and easy to be applied. But in certain situations, it is very controversial. I just provide a very recent judgment issued by Shenzhen Intermediate People's Court last year to illustrate the point. So basically, this is a case involving a will to a carer. So what happened was, in this particular case, around 1981, a married couple, the Liu and the Chen, started separating. After a number of years separation, in 2001, Liu hired another lady, a carer, to look after Liu's daily life. And then they cohabited together for the rest of life. And in July 2015, about 14 years after they started cohabitating together, and Liu, the husband, sued for divorce at the Shenzhen court. And the court ruled that the parties could not divorce. Again, the Liu, the lady, the wife, again sued for the Liu husband sued for divorce, the court ruled that the parties allowed divorce. And then the wife lodged an appeal against the first instance judgment. But during this appeal process, the Liu's husband died in August 2017 due to illness. And as a result, the second instance court issued a ruling to end the proceedings. And Liu lived with Yang before his death, right? That's the facts. So Yang submitted 2 wills to the court. The first is a written one in August 2016, witnessed by a law firm as of self-written will. In the will, the Liu said, the deceased said all these properties will be left to the carer, Miss Yang. And the second will is a printed one made in another date or a year later. The will stated the same arrangement. It will leave the property to Miss Yang, the cohabitee. And the will was signed and stamped by Liu as a testator and signed by 2 witnesses. So formality-wise, it is good will. As a court, the Yang obviously requested first to confirm that 2 wills are legal and valid one. The second to acquire the ownership of the house specified in the will. What is interesting in this is the ruling, the second instance court overturned the first instance ruling. So what court of first instance ruled? Basically, it held that the 2 wills are valid by the court of first instance, but a certain portion of common property of the couple should be given to the wife because they haven't successfully divorced yet, right? Because during the process, the husband died. So this also reflects the fact that the deceased and Yang were at fault to cohabit during the marriage. So that was the language used in the court first instance. So one property is allocated to the wife and the other to the Yang, the carer. But the second court, how that Liu dispose of the common property of husband and wife more than necessary for daily life. And cohabitation violated the duty of fidelity of husband and wife, violated principle public order and the morality, the will is invalid. So Yang is not entitled to inherit property. So all the properties left by the deceased will be vested on the wife and their children. Obviously, the carer didn't get anything after 16 years cohabitation, after 16 years, a long period of time of looking after the deceased. So obviously, this ruling triggers off lots of controversies. So what is the fear, right? The second instance court judge may think that it's fear because it's violate morality and the public order, but many lawyers and law students may not in line with that reasoning, right? So basically, the final comments I would like to provide here is fairness could be public policy driven, right? So very often, this is the case in hard cases before the highest court. Arguably, policy consideration may be a part of this justice control test. So when we dive deep into the fairness test, we perhaps need to nuance a little bit by incorporating this public policy dimension of the story. And in common law court, for example, very often they have this floodgate uplifting theory. So they fear that if we rule as such, it would lift up the floodgate by inviting more litigations to the court. And also another example is business efficacy consideration. We want to interpret the contract to make it work, right? So, and the list goes on and on. So basically that is all the policy dimensions consideration. The final point I want to make in the fairness path is the fairness control is delicate exercise, right? When the case is inextricably linked with morality as the customs. So in the case illustration I made just, is linked with morality, right? So the second instance court say, well, because it's a violation of the registered marriage, because husband and wife, before you divorce, you cannot start cohabiting with others. So you're under fault. So as a result, the will not be recognized. But what is fair pursuant to the black letter rules may not be well received or shared by the certain community with a deep-rooted customary law. In the interest of time, I did make another example. For example, when we invoke the civil customs in some ethnic minority groups, right? If we rigidly apply the state law, black letter rules, and the final ruling outcome may not be well received by the local ethnic minority group, applying the deeply rooted civil customs. So in that situation, there is a clash between, I think it makes a judge a very difficult position, how to frame the argument. On the one hand, they cannot violate the state law, because still in the same jurisdiction, the state law takes precedence, right? But on the other hand, you want to make sure that the ruling will be well received by the local community, because if not, then whenever there's a dispute happen later, the local community members will not use the court anymore because they lose the public trust over the judiciary. So that is obviously is another thing I want to provide a small footnote for Professor Thomas Muller's presentation. So time is up. I better stop here. Thank you very much for your patience.
Thanks for Professor Chen Lei's comments from perspective of especially emphasize on facts finding and public policy. And we will welcome our next commenter, Shuai Honglan from Jiangsu University.
Hello, Professor Marlins. Nice to meet you. Thank you for your wonderful presentation. I have learned a lot from your presentation. Other commenters have provided a lot of comments and useful comments and important comments for this presentation. So I just want to focus on one point that is very relevant with the Professor Chen Lei's point. Because my major is criminology and more probably is sociology, and I have focused on the empirical legal research. So here I have one question. You have mentioned the justice, which is one of the goals that the decisions, the legal decisions made. Every lawyer should make a justice and legal decision, but as we all know, the concept or the perception of justice is very different from between different persons. In my previous research, I have explored the public perception of justice, or the conception or the concept of justice, and I have found that many factors have influenced the public or the people's perception of the justice, such as the demographic factors, such as personality traits, and such as some other experiential factors, such as like the victimization and the degree of fear of crime, such as just like that. So we have a conclusion that different people have different conception and different perception of justice. So here we have one question: if the court has made a decision that is very well reasoned and well argumented, but the public or some of the public don't think the decision is justice. They may have some other factors to considering to be considered. So there are. So how do you think about this phenomenon? Do you have any ideas or do you have any suggestions to address it? So this is my question. Thank you.
Thanks, Professor Shuai. And next commentary is from CUPL, our very handsome French style, Professor Zhu Mingzhe. Yeah, he is very humorous in CUPL.
Thank you. Thank you very much, Professor Lee, and thank you very much, Professor Merles, for your very insightful lecture. So actually what I interest the most is the very last part of your lecture that concerns the creativity of legal methods and the judicial reasoning. But in my comments, I would love to stress on probably two dimensions of legal reasoning. The first one is, as I mentioned before, the creativity of legal reasoning, and what's particularly in my mind is the recent controversial, the methodological controversial over climate change litigations, particularly in the EU. As you know, that when it comes to climate change, several European jurisdictions have been very creative in certain way. For example, in the Netherlands, they, well, I mean, it's also still a pending case, but judges are discussing and also lawyers are discussing whether it is just or equitable to hold, for example, private entities accountable for their historic emissions. And also in France, the Paris Administrative Court has held the French government responsible for the ecological damage because of not respecting the climate policy, etc., etc. So now, people like Benoît Maillard, French colleagues, and me, myself, and several Dutch colleagues, we are debating on whether it is right or whether it is a methodologically sound or reliable or good to, you know, creatively apply certain existing provisions and give them completely new meanings that's never in mind of the creator of those provisions. So I would love to learn from you. What do you think? And I mean, for my personal position is there is no one single eternally good interpretation of law, and the interpretation of law have to be evaluating with the society and with the societal transformation. It's only a question of a good legal argument, and then we can debate on the standards of good legal argument. So the second dimension I want to touch is the universality of these good standards. So I think one key theoretical difference between me and Professor Li Zhongxia is whether there is universal standards. For me and probably Professor Chen Baifeng as well, legal reasoning is also a very culturally embedded topic. Different legal culture probably will propose their own standards of good legal reasoning. Therefore, legal reasoning is in a way both, how to say, normative, but also empirical. Normative in the sense that there are certain rules that a legal culture expects lawyers to follow. However, also empirical in the way that you need to dig out the legal experience of certain legal culture to really understand what is the requirement of this particular legal culture. For example, in China, when I do my surveys on how Chinese lawyers think or how Chinese judges think, surprisingly, I discovered that they count very much on policy, not on legislative provisions. And sometimes, especially grassroots judges, especially that we call 基层法官, the judges who work on county level, they sometimes even distort the literal meaning of legal provision by the necessity prescribed by non-binding policy. So I'm always skeptical towards the universality of any standard, but these empirical survey maybe even more concerned with the utility of theoretically discussing the legal methods. And probably what I would propose, I mean, I'm not totally relativist in that at that point, and I would certainly not say that you cannot critically engage with the criteria of a particular legal culture. So, for example, I wouldn't say that it is completely right, it is free of criticism that Chinese judges would put policy decisions even higher than the literature meaning of legislative prescription. But I would, at this point, I would probably propose a new discipline or a new dimension of inquiry that can probably be labeled as comparative legal reasoning. So we can not only study comparative law, but also study comparative legal methods to see how a particular given legal culture perceive things or perceive the relation between politics, law, and social transformation. That's so much for my comment. I would be very pleased to listen to your response. Thank you very much.
Thank you, Professor Zhimin's comments. He emphasized on policy driving in Chinese local court. Yeah. Our next commentary is from Shanghai University of Economics and Law, and Ma Qiangwei. Yeah, Qiangwei. Yeah.
Good afternoon, Professor. Thank you for the lecture, and thanks for Professor Li for the invitation. It was for Harvest tonight, and it's very glad to see Professor Merles again. I can't call it a comment, only some raw thoughts and confusions. I have two confusions. In the whole process of studying and researching, we can see the issue of legal method is an inescapable problem. The legal rules presented as words text lacks the dangerous tools when applied in need to be interpretation. It can be said that the main goal of the legal education is training students how to interpret and apply law. In this, after years of legal study development, we have become more familiar with Savigny's canon of interpretation, and we have become very familiar with the methods of legal dogmatics. However, the work of legal interpretation faced by German and Chinese lawyers is very different. On the one hand, we can say that the German legal doctrine is already more developed. On the other hand, after only about over 40 years legal construction, many issues have not yet been seriously studied and discussed in China. In addition, there is a big difference in the quality of legal text between German and China. We can say the legal text of China seem to be unclear and have so many gaps that need to be filled. It's also difficult to find out what's the legislator's intention. In many times, we have to seek the purpose of the norm when we use the law. In my studies and research, I often run into the question, what's the purpose of the law? And what are the ways to find out the purpose of the law? That's my first confusion. And also, as the professor says, the judge has the duty to give reasons because people have to have the right to be heard and the judge has the duty to discuss the arguments of both. However, in China today, the judges rarely give reasons for their legal decisions. Judges and scholars are in a isolated state, and it's difficult for the opinions of scholars to influence the judges. It seems to be that the judge in China has more influence by the political. So I would be curious to know if there has been such a situation in German legal history, and what can be done to improve it. Okay, that's all. Thanks again.
Thanks for sharing your short comments. And our last comment is Dr. Zhang Feihu. Yeah.
I will first comment in German. After that, I will translate in Chinese. Okay, first, zunächst möchte ich Professor Möllers danken für die wunderbare Präsentation. Ich möchte hier einfach nicht sozusagen kommentieren, sondern möchte ich meine Erfahrung in diesem Semester mit Ihnen teilen. In diesem Semester habe ich eine Vorlesung über sogenannte Recht über fairen Handel geboten. Für diesen Kurs habe ich den Begriff des fairen Handels weit gefasst und daher Betrug, Nötigung, AGB und Störung der Geschäftsgrundlage in den Kurs aufgenommen. Also ich muss zugeben, dass ich vor diesem Kurs die Bedeutung und Wichtigkeit der juristischen Methoden nur oberflächlich verstanden habe. Bei der Vorbereitung auf diesen Kurs, insbesondere auf den Teil des HGB-Rechts, wurde mir die Bedeutung der juristischen Methode, vor allem die Rechtsauslegung, bewusst. Also im chinesischen Zivilgesetzbuch gibt es nur 3 Artikel, die allgemeine Geschäftsbedingungen regeln. Deshalb beruht die Auseinandersetzung des AGB-Rechts im chinesischen Recht fast ausschließlich auf den Rechtsauslegungen. Im Laufe der Vorlesung habe ich festgestellt, dass die chinesischen Studierenden noch ziemlich angerüstet sind, was die Anwendung juristischer Auslegungen angeht. Das gilt natürlich auch für mich. Deshalb möchte ich eine Frage stellen. Auf welche Weise können sich die chinesischen Studierenden juristische Denken aneignen? Also in Deutschland gibt es neben den Vorlesungen auch AG-Kursen, gibt es auch AG-Kurse. In den AG-Kursen machen die Studierenden viele Übungen und dadurch erwerben die deutschen Studierenden das juristische Gedanken. Aber gibt es fast keinen AG-Kurs in China, dann wie können die chinesischen Studierenden das juristische Gedanken erwerben? Gibt es eine andere Lösung vielleicht? Vielen Dank. 就是我这里就是也不算严格的这个评论，就是因为我就是根据我这学期上课的这个经验，就是有这个感觉，就给大家分享一下。就是因为我这学期上了一个公平交易法，那么这公平交易法当中呢，我就把那些民法当中跟这个公平交易有关的，比如说欺诈呀、胁迫呀，还有格式条款这些东西放到进去了。然后在讲课的时候，我就发现，就是我们的学生对这个因为我们国家格式条款非常简单，只有3条，但是呢，这3条课我讲了1个月还没有讲完，就是因为在这个过程你要不停的用这个法律的解释的方法去解释3条当中每一个，甚至每一个词都要去解释。所以呢，就在这种情况，就发现我们学生对这个法律解释的这种，不管是方法也好，运用也好，好像是有一点欠缺。所以呢，我就提了一个问题，就是在这里问，就是有没有什么方法可以帮助大家， 就是像我们中国这样的学生，因为我们没有那种，因为德国有大量的练习课，就是他们在这个教授上完课之后，他们几乎都在上这种练习课，做作业，通过这种方式获得不停的去练习这种思维方法。但是我们国家因为没有这样的课，虽然我们在这里，今天我觉得大家听了这个东西，可能如果你不用的话，我估计就很快就会忘掉。所以我想知道，就是在这个除了像德国这种系统的训练方法之外，有没有一种更好，也有没有一种适合像我们国家这种没有系统练习的这种法学教育，怎么来获得这种帮助大家获得这种思维
？Thanks for Feihu's very good question. Yeah, and at last stage, I will invite Professor to make a short response and summary. Yeah, welcome, Professor. Yeah.
Yeah, first of all, thank you so much for the detailed commentaries in German and in English. I got the feeling that everybody of you really got very familiar with the topic and then created a couple of new ideas. So I'm very happy to try to answer the questions now in just 5 minutes, but also, if you like, per email in a second way, more profound. So I like to start with Professor Li Song Xia, who also gave me his questions in a written way before. One question was, do you have the same legal methods in civil law and constitutional law and in criminal law? And I would say yes and no. Yes, because my book tried to say that 80% of the tools of the arguments are similar, but on the other hand, also accepting that 20% are different. In criminal law, I gave the example that you really must look for the wording, that analogy is prohibited. And in constitutional court, you have very vague human rights. And so balancing is a very important tool. Where in civil law, we try to be more precise by checking preconditions very detailed. So indeed, there are differences that you have to take into account because you have different persons. You have private persons where you can be more tolerant because we can bargain. And in public law, you have the state, and private people. And then you also try to make sure that the state should follow fixed rules. That was the first question. The second question was, is there a difference between interpretation and construction? Or is there perhaps not an overlapping part of legal terms? Indeed, it's not in each time easy to say where you can make a clear difference. But I think interpretation is a way to find the law where you can really work with the wording quite helpful. And if we speak about construction, we create something new. We create, for example, the question global warming and the cases in Netherlands. If when the courts create new rights for the parties, when we are leaving the way of interpretation, but we construe something new. Now, to Professor Lai Chen, I was very happy that you could give me your practical experience as an arbitrator, and I'm absolutely with you that finding the facts is very often, not taking seriously. And if I'm writing legal opinions, I'm learning that it sometimes needs 50% of my time just to make sure that I have the facts. Or if I don't have the facts, it will be much harder to create the law, because if the facts are fulfilled, then I just can use the existing law much better. The second question is a little bit comparison to a question of Mrs. Chuen Hong Lang. Justice, fairness. Is it not dependent on the legal background, the legal culture of your country? Absolutely right. That means if I giving you my book, we have the legal tools, but you have to use and move the tools to your legal culture. And if in China, for example, the constitution is less important than in Europe, this constitution cannot be used as higher binding arguments. Or if we have the power of separation in Europe, and you have perhaps the power of concentration because the party defines the rules, then you have to accept that the party has the last word in interpreting issues. So I once gave a talk about data protection, and we spoke about the data protection of the people. And then the professor told me, wonderful, we in China also have data protection as the goal, but we have another principle, that's efficiency. And we have a third principle, that is the state interests. And we have balanced the three principles and then find a solution. And if you have additional principles in your legal area, your legal culture differs, and then it's, I think, correct, yeah, to create a different result because you have perhaps a different way of values. So I would never say that we have one universal answer all over the world. It would be stupid, yeah. I would say try to use the tools, try to use the arguments, but concentrate them to the legal values, the legal principles you have. And they don't have to be identical, yeah. All over the world, they can differ. So the question is, and your question was, how can you fill up gaps? And do you have the right to debate? That is the important question that we also learned with Mr. Chu Ming Cheng, when we spoke about Netherlands and the global warming debates and the climate claims. Do courts have a right to create new claims, new rights? That is one of the very hard questions in the chapter development of the law. In Europe and in the United States, courts are part of the political discussion. They are part of a political discussion to solve open questions that had not been decided. But our courts normally are very wise by just saying there is the duty to do something, but dear state, dear parliament, you have the discretion how to go on with the problem. Our German Constitutional Court, for example, created a right of the next generation, a right of the next generation not being harmed by global warming. So the duty is our parliament has to create rules against global warming, but we have the discretion how we fill them up. Number 5, Mr. Ma, you asked what is about legal training, what is about legal reasoning by judges. We have totally different legal styles if you read court decisions. In France, for example, in the past, we had just 1 or 2 sentences. And it was a little bit like Germany 300 years ago. Their courts didn't give any reasons because they said, if I give reasons, I have to debate, I have to argue, I don't like to debate, because I have a power. But that is not the modern approach. The modern approach is if we leak legal peace, if we leak acceptance, we have to accept, we have to persuade the parties. And so in English court decisions, in American court decisions, in German court decisions, we are open by arguing with pros and cons, by giving the two parties the audience to argue. And then we are looking for the best and the most persuading argument. So I think it's a development. In European law, the European Court of Justice didn't argue 50 years ago. But nowadays we had made a lot of pressure, and nowadays Savigny, the 4 arguments, wording, systematic, logical, historical will, you find in each second or third decision, because now it's the state of the art. So, and the very last question of Mr. Faihu Zhang, how could people be trained in legal methods? In Germany, we have a subject of legal methods in our second or third year. All students can choose it. That means 80 or 90% of our universities have legal method as a subject to deepen the legal knowledge, because we say learning the texts, learning cases is one hand, but on the other hand, there are so many gaps, there are so many unclear provisions that we must learn people to think. Learn how to fill up questions where there hadn't been any clear answers until now. So legal thinking is, I think, at least as important as the knowledge. You need legal knowledge, of course, you need the texts, you need the cases, but you should know why, you should look for the arguments, and you should have a capacity to go on by your own head and think for yourself. So that are my 5 minutes. Thank you so much for listening.
Time also goes very fast, and we will tonight we have a very good delicious dinner from the lecture, and we also hope thanks for professor and all commenters again, and we also hope we could invite professor and all the other commenters could visit our campus maybe in future and give us also more and more lectures. And next month, professor also will give another lecture about the capital market, also the securities law on via Zoom, maybe on the December the 9th. And the next lecture will about the quasi in contract law will be held on November 23rd by Professor Albert Gregor. I also welcome everyone who will join in our lectures next week, December. And thanks again for professors' very splendid lectures, and I will hope every student could read your very good book, Legal Method.
Mr. Lai, thank you so much for the lecture, and thank you so much for joining this lecture. It was a pleasure for me to give this talk. Thank you, and bye-bye to everybody.
Bye-bye.
See you again.
Bye-bye.
Next time, 好，也谢谢大家，听得怎么样？其实教授的东西的内容。